3, 2, 1, start. The petitioner did not complete 10 years of continuous service against any sanctioned post, and as such, the ratio of the judgment delivered in the case of MLKSD Supra is not applicable to the facts of the instant case. Stop para. In the case of Niyal Singh Supra, the appointment was made resorting to the provisions of Section 17 of the Police Act 1861, whereas in the instant case, the initial appointment of petitioner was not in accordance with any statutory provision, and that as such, the judgment delivered in the case of Niyal Singh Supra is distinguishable on facts. Stop. This court cannot compel the respondents to create post and to absorb the petitioner on a permanent basis. Stop para. The judgment delivered in the case of Amarkant Rai Supra is also distinguishable on facts, in as much as in the same the appellant worked for 29 years and the Human Resources Development Department of the government agreed that the services of the employees, including the petitioner working in the concerned educational institution on the basis of the prescribed staffing pattern, is to be regularized. Stop para. The sequence of facts, however, reveals that the petitioner's appointment was not a backdoor appointment, in as much as the petitioner had the requisite qualification and his name was duly sponsored as an ex-serviceman by the Fort William authorities pursuant to requisition of the said institute, and upon emerging to be successful in the selection process conducted by the said institute. The petitioner was appointed as security in charge, and there has been a continuing necessity to engage a security officers. Stop. Such contingency is still existent and is evident from the fact that the respondents are desirous of appointing a fresh incumbent on the basis of the advertisement impugned. When an ad hoc appointment is continued for a long time, the court presumes that there is a regular need for the petitioner's services. No document has been placed before this court to show that the respondents were dissatisfied with the service rendered by the petitioner. Thus, the factors which impelled the respondents to deny extension of service are nothing but the mere whims of the employer, and such action, even in contractual engagements, cannot be excluded from the purview of judicial review. Furthermore, arbitrariness is presumed, since the petitioner engaged on purely temporary basis has been sought to be substituted by another person on temporary basis, and that too without any reason. The continuance of the petitioner, who has gained experience, will be more beneficial and useful to the respondents rather than to appoint the person fresh on ad hoc basis, and such process as adopted castigates the action of the competent authority to be punitive in nature, and in the circumstances the petitioner has a very serious claim to continue in the concerned post till regular appointments are made. Stop. Regular vacancy would mean a vacancy which occurs in a post sanctioned by the competent authority. Stop para. Needless to observe that the respondents can always discontinue a temporary engagement in the event the service rendered by the concerned employee is unsatisfactory, or in the event the employer loses confidence over the said employee. Stop para. The legal position in relation to termination of service of a temporary employee is to a substantial extent similar to that of discontinuance of an employee in probation. Discontinuance, termination in accordance with the procedure established by law, is an integral facet of right to life and livelihood assured by Article 21 of the Constitution, and any procedure to deprive such a right must be just, fair and reasonable. In the instant case, the procedure adopted by the respondents to discontinue the petitioner's contractual engagement is unreasonable and unjust, inasmuch as the respondents want to disturb an ad hoc engagement by another ad hoc engagement through an advertisement to that effect. Stop. Though the petitioner may not be entitled to regular appointment, it cannot be said that that he should not be continued till regular incumbents are appointed. Reference in this connection may be made to the decision of the Honorable Supreme Court in the case of Hargur Pratap Singh versus State of Punjab and others, reported in 2007-13 SCC 292. Stop para. The advertisement was published prior to disengagement of the petitioner, and a perusal of the document at page 66 in affidavit in opposition reveals that the director's note dated 31st March 2015 did not specify that applications for the post of security officer will be invited by way of an advertisement from persons not below the rank of colonel. The term "not below the rank of colonel" was incorporated to avoid the allegation of arbitrariness. Stop para. Clause 9b of the regulations and bylaws provides for extension of contractual engagement for a period not exceeding 5 years, but in the instant case the petitioner's contractual engagement was extended for more than 9 years. The document at page 64 of affidavit in opposition is a notification dated 21st March 2013 pertaining to a scheme of engagement of consultant, which entirely provides for engagement of a consultant under categories A, B, C for a period of 1 year at a time, subject to maximum age limit of 65 years and subject to approval of the director. Stop. The document at page 61 of the writ application reveals that petitioner's extension was on the basis of such scheme as a consultant under category C of the scheme and at a fixed remuneration of rupees 25,000. There is no allegation to the effect that the petitioner's rendition of service was unsatisfactory, and only with an intent to discontinue the petitioner after 9 years through a further ad hoc appointment, the clause not below the rank of a colonel was inserted. Stop para. In such fact situation, it is explicit that the respondents have acted in an arbitrary manner and have exercised uncanalized and drastic powers to discharge the petitioner, taking advantage of the lack of equal bargaining power of the petitioner while entering into a service contract with the respondents, and this court cannot approve such an unconscionable action. Stop. Reference in this connection may be made to the decision of the Honorable Supreme Court in the case of Balmain Lowry versus Partha Sen Roy, reported in 2013, 4 CHN SC 124. Stop. The courts adopted by the respondents to discharge one ad hoc arrangement by another ad hoc arrangement is not at all appropriate. Stop. Accordingly, this court directs the respondents to allow the petitioner to continue to serve as security officer of the said institute and to grant all consequential benefits thereto till a permanent post of security officer is created and sanctioned, and till permanent appointment is made in such post through a regular selection process. Stop. With such observations and directions, the writ application is disposed of. Stop. In the facts of the present case, there will be no order as to costs. Stop. Urgent photostat certified copy of this judgment is applied for be given to the parties as expeditiously as possible upon compliance with the necessary formalities in this regard. Stop.